Since coronavirus is so prevalent in the news and on people's minds across every industry, I was wondering if from the legal perspective, if coronavirus planning, organizational planning, legal planning, if there were some lessons learned from SARS and earlier outbreaks that your firms may be taking with you or applying to this, or what are some of the things that are making this perhaps a unique situation where past knowledge really doesn't help much?
One comment I would say for employers, I suppose, is that some of their flood planning even has been real helpful. Certainly SARS and things like that, if you've done that sort of planning, which I think if healthcare and those sorts of agencies have done a lot more planning for epidemic and pandemic, but for a lot of employers, it's really an emergency plan, right? What do we do if we can't get in our office? What do we do in case of emergency? And all employers really should have that sort of plan in place. And I can say even internally in our law firm, it's more things like flood planning. It wasn't that many years ago when our building downtown was too close to the river and we had to move out west for a little bit. And so looking at things like how would we handle our operations if we couldn't get into our building when the Yonkers building burned down. I know you guys were restricted for a few days. Okay. So, there's lots of emergencies that can come up. And I think all of that emergency experience, whether it's because of a virus or a flood or an, unpredictable fire, all of that experience is helpful here, thinking through what worked well, what didn't work well, and how it might need to be adapted, and doing that exercise on a somewhat regular basis going forward so that it isn't a panic situation and your employees are maybe not as scared because they know what the plan is. But I'm sure in the healthcare industry, there's a lot more to it.
Well, and you guys probably don't want to talk about emergency rooms or any of the rest of it. But I would say that one of the things that I think is really different from what planning would have been if you haven't done a lot of emergency planning since we've had a lot of flooding or that kind of thing is the ability of people to work remotely. I think that's changed really significantly even over a 5-year period, how frequently we work remotely. And there's a lot of things that attach to that, like how do you pay people? How do you track their time? And because I do data privacy and security, how do I keep your data secure when I have more and more people accessing it from a remote place? For some people, it doesn't matter as much that the data is secure, but if you work for credit unions like I do, or you work for banks or hospitals or insurance or any of that, data security becomes a huge issue. So that's, I think, a piece that I've seen, at least for a lot of my clients, that's missing in their contingency and emergency planning because they didn't think about it that much the last time we had a flood. So I think that is a place that we're going to want to really focus on.
So are saying, okay, well, work from home. What are some potential pitfalls that you see businesses running into from a legal standpoint when you start trying to do that? Are there some things that people run across?
Sure. I think there's some really common things. And actually, the first one is just having the right infrastructure to do it. If I tell 150 people they can work from home, do I have 150 computers? I mean, do I have bandwidth to let 150 people log into my system? Can I manage that? So I think really just some of the real practical things. The other thing that I believe the Department of Labor struggles with is how do we account for that time worked? If I log on and I spend 30 seconds, is that time worked? If I'm an hourly employee versus I spend 25 minutes, and we have trouble with people tracking the time, and I always want to make sure people are being paid, right? They got to be paid for the work that they do. And then we run into the data security issue as well. And then my personal favorite, if you're carrying your workplace computer and you trip down your stairs and break your leg, it's going to be a work comp claim. So I got to think about work comp as well.
One of the things that I think I am curious about is when you are in this emergency type of a situation, oftentimes the business is trying to operate with the best interest of the business, but also of their people, but they can make mistakes along that way because they're operating fast. So how do you see that play out in those situations where 3 months down the line somebody's making a claim
for wages or?
Yeah, I'm not sure the exact legal situation, but somebody might run into a legal pitfall while they're trying to operate in a very fast environment when things are changing very quickly.
Right. I do think that there is a little bit of wiggle room. I mean, not a lot. We're lawyers, so there is not a lot of wiggle room. But there's at least a little bit of wiggle room when we do those things. And I certainly had clients where we've had some actually already workplace exposures, and we've had people say, do we pay people? right? I mean, they weren't exposed, we don't know if they were exposed, but if they were, are we going to pay them because it might have been at the workplace? And one of the things they're worried about is opening the door to paying everybody who gets exposed to a cold or the flu or anything else in the workplace. And what I've been telling them is I think this is a unique situation, and that, you know, making that decision now isn't necessarily going to be the decision we're going to have in 6 months, but you have to build that into your communication, right? You have to tell your people, we are continuing to monitor the situation, and these policies may change as that situation changes. You need to tell them that kind of communication up front.
One of the other areas where I think sort of panic can start to cross the line into stepping on your employees' rights is with respect to employee medical information and medical testing. So generally speaking, you cannot conduct medical testing on your employees unless you have a business necessity to do that. And that includes things like taking your employees' temperature, asking them questions like, do you have coronavirus? And, you know, do you have underlying health conditions that we should be concerned about, right? You can't ask those sorts of questions. And I think there is a danger in this situation that we care so much about protecting our employees and keeping them safe that we start to ask questions and take steps that maybe we can't do. Now, there is a point at time where you probably can take your employees' temperature. The EEOC has some, you know, pandemic guidance where they recognize that at some point there's a business necessity. But what might be a business necessity for a nursing home, for example, may not be a business necessity for a law firm. And so that's one place where I think there is some risk in trying to do the right thing and keeping your employees safe and potentially crossing some lines that the law doesn't allow us to cross. And is somebody going to sue you because you took their temperature? Well, I don't know, right? Maybe.
Well, and one of the things that we find is that the guidance from the agencies like the EEOC and OSHA and the CDC don't always mesh, right? So the CDC would like us to take people's temperature. OSHA's sort of neutral in the temperature thing, I think, right now, and the EEOC doesn't want us to do it. And so you have this sort of dueling imperative from the various agencies. Every agency really cares about its own rules, but we have to care about the rules of every single agency that governs us, and so it gets really complicated as employers.